So without any further ado, first speaker today is going to be speaking to you about an update in the law on labor law section 240.16, and I'm not sure if Tony's going to touch 200, but what Tony's going to do is provide you with an update of all of the recent cases from the year 2012 in the area of construction accidents and labor law. Most of you know who Tony Gair is, and he typically does not even need an introduction because he's that well known throughout the city and the state of New York. Tony is one of the senior partners at my firm, Gair, Conason. He's been practicing for more than 25 years, and he truly is the person that when many of you in the audience and lots of others who are not here have any question about the labor law, and not just the law, but also how to prosecute the case, how to try the case, Tony is constantly, all day, every day, fielding phone calls from lots of practitioners. And to me, that's the highest compliment that he could ever get. Yes, he's one of the best lawyers in America and all of that, but the bottom line is he's really a lawyer's lawyer. And without further ado, here's Tony.
Thank you, Howard. Can everybody hear me? Okay, a couple of things. First of all, there is no way I'm going to be able to talk to you about all of the cases over the past year. Did everyone get this email with the links to the course materials? Great, because last week we were in Long Island doing this, and a lot of people didn't get it. There's 3 submissions, one by myself, Howard and Chris Sally, one by Tim Higgins in Albany, and one by Brian Shute. And between all 3 of those submissions, all of the 2012 cases are in there. Let me just ask you very quickly, how many of you practice in the field of construction accident law on a regular basis? Okay, a few of you. Okay. And I think there's a lot of people from carriers here today, right? Raise your hand. Okay. And a lot of defense counsel I recognize. All right, without further ado, I'm not going to talk about 241.6. I just don't have the time. In Brian's Schute's submission, there's a lot of 241.6 cases. I'm going to be talking to you about Section 240. Why? Because that's where really all the action is and all the changes have occurred over the years, and certainly over the last year. I think we can all agree, those of us who practice in this field on a regular basis, that the law under Section 240 of the labor law is constantly changing. It's almost like the criminal procedure law when you read the cases from the United States Supreme Court. It's like a pendulum. It goes for the plaintiffs and back to defendants, and then sometimes in the middle. In the late 70s, from the time that Haynes versus New York Telephone was decided in 78 with an opinion by Jack Fuchsberg, till the early 90s, there's no question about it, the law favored the plaintiffs. Then we saw a change in the late 90s with cases such as Ross versus Curtis Palmer and Rockovitz versus Con Ed. And then, of course, in 2003, we had Blake versus Neighborhood Housing Services on the sole proximate cause defense. Cahill, which changed the recalcitrant worker law. And then back again in 2009, which was the case that changed everything. And that's Runner versus New York Stock Exchange. How many of you here are familiar with the facts of Runner? Okay, just a few. I'm going to go over it very quickly because it is so important. I always say that it would be nice for us as lawyers to know exactly what the law is in this area of the law, 240, and for there to be some consistency. Historically, as those of you who practice in this field know, 240 cases are very case-specific, fact-specific. But I have to tell you that since Runner, which really changed this and really slanted it towards the plaintiffs, the court has been consistent. So what I want to do is focus on concepts, because that's what's important right now, the concepts that have been introduced since Runner. So, by the way, let me just, how many of you know Blake? All right. I'll get to Blake, but Blake versus Neighborhood Housing Services was a Court of Appeals case. There had been one or two cases before on this sole proximate cause defense. Where that came from, I don't know. Well, I do know. It came from the minds of some very sharp defense lawyers. And I think they looked at the superseding intervening cause cases, Cush versus City of Buffalo, because we know that culpable conduct is not a defense to a 240 action, and came up with a sole proximate cause defense, which is really, if you look at it, theoretically the same as a superseding intervening cause. So it takes, it's not culpable conduct, it's solely the fault of the plaintiff. And if you read Blake, the most important thing you have to understand about Blake is, and it's 2003, so I'm not going into it in detail, but remember this about Blake, and Blake remains good law. Once a plaintiff shows a failure to provide a 240 enumerated safety device or, quote, other device, the plaintiff's actions cannot be the sole proximate cause of the accident. If you concentrate as a defendant's lawyer, and I'm not up here today as a plaintiff's lawyer or a defendant's lawyer, I'm trying to be objective and tell you what the law is. These depositions for the defense become very, very important, because even if a safety device has been provided and you're not going to win your motion for summary judgment, you may be able to create a question of fact as to whether the plaintiff's actions did constitute a sole proximate cause and go to the jury on that. So that's very important. And I noticed there was a lot of people, I saw a number of people from Zurich, and we were with you guys all the time, but it's really important. This is what we do. Chris Sally got me into the habit of doing it. The minute we get these cases, and we get them after you, we go out and see the witnesses if we can, and we get affidavits to nail them down. So as a defendant, certainly when you're with a carrier and you get notification of these cases, get an investigator out there right away and see if you can nail the witnesses down before the plaintiffs do. Okay? And because it becomes very important so that whoever you assign the case to will have something to work with. Okay, Runner versus New York Stock Exchange. I talked about this last year. How many people were here last year? Okay, 1, 2. Ginny, you were here. Where are you? Back there, son. Okay. Since some of you don't know the facts, I want to talk to you about it because, as I said, it changed, and as Brian Schutz said, it changed everything. It's been cited. It was decided on December 17th of 2009. It's at page 62 of the Gair et al. Submission, and it's also in Brian Schutz and Tim Higgins' submission. It's already been cited over 100 times. It's a great amount of cites. Here's what happens in Runner, and it's important because of the concepts. The plaintiff and co-workers had to move a large reel of wire weighing 100 pounds, 800 pounds, down a set of 4 stairs. And here's what they're told to do. They're told to take the end of the 10-foot rope, wrap it around this huge reel of wire, and then bar horizontally in a door frame, wrap the rope around it, and 3 workers, the plaintiff and 2 co-workers, are holding the rope, and so they're like counterweights that you see on cranes, and with this 800-pound reel of wire, and the other workers start pushing it down. Well, imagine what happens. Once this thing goes down the stairs, it pulls the plaintiff right into the bar, and he severely injures his hands. This case was tried to a verdict in federal court. It was a defense verdict. The judge tossed it, directed verdict for the plaintiff. It went up to the Second Circuit. It was certified to the Court of Appeals. Now, remember this. The plaintiff didn't fall. He wasn't struck by a falling object. Doesn't fall. It's the reel of wire that falls. And this is the most important and crucial statement in Runner. And it was by Judge Lippman who wrote the decision. And I just want to quote it to you. The single decisive question is whether plaintiff's injuries were the direct consequence of a failure to provide adequate protection against a risk arising from an elevated differential. And the reason I say it's crucial, because in the couple of years after Runner was decided, it's my belief that it was misinterpreted by the certain appellate division decisions, as well as certain commentators, because of this statement, which in Runner, where Lippman said, the relevant inquiry is whether the harm flows directly from the application of the force of gravity to the object. Well, that's true within the context of the facts of Runner. But you gotta put it in context. Don't think that force of gravity alone is enough as a plaintiff to give you a 240 case. It isn't. You need an elevation-related differential. Not as high as you used to, but you need it. And if you put it in context, when Lippman wrote that in Runner, the language comes directly from Ross versus Curtis Palmer, a 1993 case, and it's in the materials. The site is. But in that case, for those of you who may remember it, and it really was a change at the time when we started leading towards the defendants. The worker's way up in the air on the scaffold, and because of the way the scaffold's positioned, he's got to bend over, and he injures his back. He doesn't fall, and the case goes up to the Court of Appeals, and the 240 case is thrown out because although he was at an elevation, the force of gravity didn't act on his body to cause his injury. So that's where that language comes in. And it also was cited from Rockovich versus Consolidated Edison, which was a 1991 Court of Appeals case where some of you may remember the guy's up at a height and he's walking next to a trench with hot tar in it, and he steps into the hot tar and is severely burned. Not a 240 case because the force of gravity was not involved. So bear that in mind. This force of gravity language comes into play when you have what might be called a de minimis, but it won't be if you win as a plaintiff, a minimal elevation related hazard. That's when they start talking about the force of gravity. Now, the most important case of the last year was decided on October 25th of 2011. And that is Walensky versus 334 East 92nd Housing Development Fund Corp. It's 18 NY 3rd 1. It's at page 80 of the Gair et al. Submission, and it's in everyone's submissions. It's already been cited 45 times. How many of you here know Walensky? Okay, a couple of you do. Let me go into it. And this is how the law changes depending upon who's on the court. The majority opinion was written by Judge Saparik, and in Walensky, the court rejected the same level rule, which had first been...
Not on page 80.
It's not on page 80?
83.
83, I'm sorry. Sorry, Lou. Okay. You've been pointing things out to me my whole life.
Seems like that.
I know, but to my benefit. I'm sorry, page 83, right, Lou?
Yes, sir.
Okay. The majority opinion was written by Judge Saparik, and the court rejected what was known as the same level rule, which had been enunciated by the Court of Appeals in 1995 in Miseriti versus Mark IV Construction Company. Now you have to understand, and this is going to be very interesting this next year, you have to understand what was going on back in October of 2011 at the court. There was an obvious philosophical difference with regard to the interpretation of 240. You had Judge Pigott leading a faction consisting of Judge Grafeo and Judge Susan Reed, which wanted to interpret 240 more restrictively. Then you had the other faction led by Judge Littman, joined by Judges Saparik and Jones, who interpreted 240 more liberally, with Judge Smith coming in, like Kennedy under the Supreme Court, as a swing vote. Now, as we know, unfortunately, and very, very sadly, we lost Judge Jones. And for those of you who know him, it was a terrible, terrible loss, not only as a judge, but as a very decent and kind human being. And it's a great loss for the bar. And also, Judge Saparik is going to have to retire at the end of the year. She's reached retirement age. So there's going to be two vacancies on the court, and we know who's on the list because it was published on the Law Journal. But we don't know who's going to be finally approved by the governor, and we could see big changes or not. But Judge Littman, of course, is a great consensus builder, but it remains to be seen what's going to happen as we move forward. Okay, so as I said, in Walensky, the court rejected the same level rule as set forth in Miseriti. And the opinion in Walensky was written by Judge Saparik. Guess who wrote the opinion in Miseriti? Anyone know? Judge Saparik. Okay? And what she said is, in rejecting the same level rule, and basically the same level rule was this: if where a worker sustains an injury caused by a falling object whose base is at the same level as the plaintiff loses. Seems to make sense because there's no height differential. And cases were tossed for years. We've all had them as defendants, as plaintiffs, under Miseriti. And when Judge Saparik wrote this opinion, which is a split decision, as I said, and I just told you the judges involved, she said, based upon our changing law, our body of law under 240, and mainly she spoke about Quattrocci, which was a falling object case. Remember, you had Narducci, which came down and said, in order for a plaintiff to recover in a falling object case, the object had to be in the process of being hoisted or secured, and then you had Altar and then Quattrocci, which now say, no, it doesn't have to be in the process of being hoisted or in the process of being secured. It has to be an object that needs to be secured, or it doesn't have to actually be going on. And then, of course, Runner, which I just told you about. So, The majority then in Walensky held that the same level rule does not categorically bar the worker from recovery under. And they, in Walensky, they held there was a question of fact as to whether the injury resulted from the lack of a prescribed safety device. Now, many of you may question how Judge Separek got around her 1995 holding in Miseriti. In Miseriti, a wall had been constructed and it had been finished, and the work was done when it fell and resulted in the death of the worker. And the court held that in enunciating the same level rule, there was no proof that any safety device would have prevented the wall from falling, and also the wall was at the same level as the construction worker. In Walensky, plaintiff and his co-workers are working on a demolition job, and they're demolishing the walls of a building. They'd already demolished the ceiling and a floor above, and they'd left standing two vertical metal or iron pipes, which were 10 feet tall. And what happens is, as they're demolishing the wall, debris from the wall falls, hits the metal pipes, which is 10 feet tall, which both fall on the 5'6" inch tall worker. And the court distinguished Miseriti on the basis that the construction of the wall that collapsed there was completed, and the wall, as I said, didn't collapse because of the result of failure to provide a 240 protective device. So, Judge Separek then said, based on Runner, the single decisive question is whether there's an elevation-related differential, and argued that there was, because the pipes were 10 feet tall and the plaintiff was 5'6", and then, of course, brought up gravity, as she's going to have to, because this isn't much of an elevation-related differential, and says, and the pipe fell because of the force of gravity, the debris hitting the pipe, causing it to fall, and the pipe striking the plaintiff. In dissent, Judge Piggott, joined by Judge Grafeo and Reed, said, what are you talking about? This is classic, same level. And we don't see any difference between this case and Miseriti. And if it wasn't for Runner, there wouldn't be, because there really wasn't any difference. But the law had been evolving. That's why I say Runner changed everything. And so you have to keep that in mind. So following Runner and Walensky, we have another factor to consider in determining whether you have a 240 case, and that includes now how big or heavy the object was which struck the plaintiff or struck something else, causing that object to strike the plaintiff. Now, let me talk to you about a couple of cases that came down this year which illustrate how much the law has changed following Walensky. There's a First Department case from this year called Capisti versus 246 Spring Street. I think it's at page 88. Well, 88? It's about 88. And the court granted plaintiffs 240 some. Okay, 88. The court granted plaintiffs 240 summary judgment motion. And in this case, the plaintiff was struck on the right foot by a steel block being hoisted by a crane. And the plaintiff alleged that the crane swung improperly in his direction. The plaintiff was standing on a stack of blocks 2 to 3 feet above the ground. And I'll tell you, the block that's being hoisted by this crane was also 2 or 3 feet above the ground. And so they're at the same level. And the court, citing Runner and Walensky, stated the elevated related differential cannot be considered de minimis when the weight of the object being hoisted is capable of generating an extreme amount of force. In this case, the block weighed 4 tons. And they say even though it traveled a short distance. So even though there was really no elevation-related differential, but you have a hoisting case now. And really, I think this case turned on the plaintiff's expert affidavit. And in a lot of these cases, even though it's 240, it's a good idea to go and get an expert. Certainly, a case like this, which would have been borderline, one would think, or one would think you'd lose as a plaintiff, quite frankly. But the plaintiff put in an expert affidavit saying that the block was not properly secured by tag lines, which some of you know they attach to the crane cables and the boom, so as to prevent it from moving while being hoisted. So that was the rationale in Rubinowitz. Okay, 15 minutes? Okay. I'm trying to talk fast. I apologize because there's a lot to cover, but I'll finish on time for once in my life. There's a very interesting third department case. Kropp versus Town of Shandaken, I believe at 89, page 89, in the Gair et al. Outline. It's in the Shute outline, it's in the Higgins outline too, as I recall. It's a third department case. In that case, the third department reversed summary judgment for the plaintiff because of conflicting witness accounts. The facts briefly are this. Plaintiff is in an 8-foot deep trench. He's struck by an 18-foot pipe attached to another pipe, making the total weight of the pipes 1,500 pounds. And they're being lowered into the trench by an excavating machine. Here's what's interesting about the case. It was a question of fact because obviously if you have conflicting witnesses, witness testimony, it's a question of fact for a jury in all cases. But the court citing Walensky held that even if the pipe dropped only 1 foot, the elevation was not de minimis given the weight of the object and the amount of the force capable of being generated. And the court went on to cite Runner, saying the dispositive inquiry is not merely how far the pipe fell, but whether plaintiff's injuries were the direct consequence of the failure to provide adequate protection from a physically significant elevation-related differential. So I guess if you have a 1,500-pound object and a 1-foot elevation, it's not de minimis. Now, those of you who have studied the history of 240, what's 240 called? It's called the scaffolding law. And why was 240 enacted years and years ago before any of us except Will were admitted? No, I'm just kidding you, Will. Years ago, the scaffolding law, it was designed to protect workers who are working really way up in the air on scaffolds, and you never hear of this gravity-related language when a scaffold collapses 40 or 50 feet up on a building, because it's obvious. The only time the gravity-related language comes into play is when you have what would be forerunner, and before Walensky be considered a de minimis elevation-related differential. Another 2012 case, this one from the Second Department, page 90 of the Gair et al. Outline, is McAllister versus 200 Park LP. In that case, 4 stacked scaffolds, in other words, scaffolds that weren't in use, they were being transported, had been placed on a Baker scaffold. Everybody know what a Baker scaffold is? A Baker scaffold, you've seen them, is a metal scaffold on wheels. There's 2 wheels in the front, 2 wheels on the back, and then the boards that make up the scaffolding at whatever level you want to put them on the metal that makes up the scaffold, and it goes on wheels. So they stack these 4 scaffolds with a weight of between 450 and 500 pounds on this Baker scaffold, and they're moving them along, and the 2 front wheels on the scaffold broke, so it starts to tip. So the plaintiff squats down, and so that the front of this Baker scaffold is against his chest, and he wants to push it sideways. Plaintiff's foreman didn't realize he wanted to push it sideways, so he pushed it forward, and it falls on the plaintiff, pinning him against a wall, and he suffered severe spinal injuries. Again, citing Walensky and Runner, despite the fact that the base of scaffold at same level as plaintiff and fell a short distance, how far could have this fall? Imagine it in your mind. A Baker scaffold on wheels, this guy, the plaintiff, is in front, the wheels break, he's holding it, the foreman pushes it. It's not falling much. It couldn't have. By necessity, he's against it. Given the combined weight of the device and its load and the force it was able to generate, the short distance it traveled could not be considered to be de minimis. How much? 5 minutes? Okay. The sole proximate cause and recalcitrant worker defenses. By the way, a great resource, as you all know, is the PJI. And if you look at the cases over the last 3 years, it's apparent that the recalcitrant worker defense has really been subsumed by the sole proximate cause defense. And defendants are now moving for summary judgment on sole proximate cause, even when the worker didn't use an available safety device, and analyzing the cases on that basis. And we're back. The leading cases on sole proximate cause prior to Cahill versus Triborough Bridge and Tunnel Authority, which is no longer the law. It's cited for one reason, but it's no longer the law. It was decided in 2004, and that's the case where the worker who was working on the Triborough Bridge had been instructed weeks before to use his harness as he went up the bridge, and didn't do it on the day of the accident, and the case was tossed. Prior to Cahill, the leading cases, and I'm just giving you this really quickly for historical perspective, were Smith versus Hooker Chemical Company, which was a 1982 4th Department case, leave denied. These are all in the course book at the beginning. Gordon versus Eastern Railway Supply, Higgins versus State, Stolt versus General Fools, and Jasper Bisky versus North Shore School District. They're in the first few pages of the Gair et al. Outline, so you can see what's happened. The rule at that time was for a defendant to win, you had to, 1, show a refusal by the plaintiff to follow a direct, immediate order not to use the device. 2, an accident contemporaneous in time with plaintiff's refusal. And 3, that safe and appropriate devices were available. That's what you have to show, but not after Cahill. Then, what happened? In 2010, this is after Littman's on the court, after Runner, we have Gallagher versus the New York Post. Court of Appeals, 2010, page 40. And it's in every submission. Gallagher remains the final and last word from the Court of Appeals on the sole proximate cause defense, including not only recalcitrant worker, but misuse, if you want to say that. So there's 2 types of the sole proximate cause defense now. What we call the recalcitrant worker device is a defense, the failure to use available safety devices, and as Brian Shute likes to say, every other thing, stupid thing the plaintiff could think of doing. Okay? Under Gallagher, we're now back to where we were pre-Cahill. For defendant to win on a sole proximate cause defense, in the recalcitrant worker scenario, a defendant must show 1, safety devices were readily available at the work site. Plaintiff knew he was expected to use them. He was told or he knew about them, and for no good reason chose not to use them. That's what, as a defendant, you now must show on a recalcitrant worker case. I submit to you that we're back to an expansive reading of 240, going back to 1985, and many of you may know because it's quoted all the same, all the time, Zimmer versus Chemung County Performing Arts Center. And what do they say in Zimmer, and what does Littman write all the time, and Saparic, and all of the judges who come up with a pro-plaintiff's decision, which I'm not saying are wrong, they are what they are. Section 240 shall be construed as liberally as possible to achieve the purposes for which it was enacted. That was 1985, and I think that's where we are now. Blake versus Neighborhood Housing Services is still good law. I submit to you, you have to now show a misuse. What Brian likes to call, as I said, every other stupid, idiotic thing a plaintiff could possibly do. But a misuse, not a mere misplacement. Some of you may remember Montgomery. Montgomery is only good law because the Court of Appeals stated there that there was a ladder available for the plaintiff to use, and Montgomery's in the course book. There was a ladder available for the plaintiff to use, and he didn't use it. In point of fact, and so Montgomery cited for that, and if one assumes that a ladder was there, that's still good law. The fact is that there was no proof one way or the other in the record, and I've read the record, that a ladder was even there. But they assumed, for the sake of the decision, that a ladder was there. So when you see Montgomery cited, remember, it's because they're assuming a ladder was there and the plaintiff didn't use it when he stepped up on the bucket to get up to the elevator shaft and then jumped back down and was injured. Cahill is followed to the extent that if the Gallagher factors are met or the plaintiff misuses safety devices, and that's it. And I think I've finished on time.
The first time ever.
Thank you very much.
Tony, thank you very much. And It really is the first time that he's ever finished on time. And we will try to keep it, ladies and gentlemen, for you on time today, as close to timing as we possibly can. He wants to say one more thing. It's too good to be true.
No, I'm sorry. It's for the, because there's so many people from the defense out here. Listen to, at page 489 of the PJI, it's part of the 240 charge, but you have the charge 2:217.2, page 489 of the 2012 edition, and it's a recalcitrant worker charge. They make a mistake in there. They say it's based on Cahill versus Triborough Bridge and Tunnel Authority. It isn't. It's based on Gallagher, and if you read it and know it as a defendant, so when you start out with your case, you know what you're going to have to prove. Callie would kill me if I read it to you, because I would then be able to go over as I usually do, but I'm going to break with President and sit down.